My name is Sharyn Eklund. My mother was subjected to exploitation and abuse by a guardian operating within the failed Massachusetts trial court system. I have tried to find judicial oversight and accountability for this failed system, but the governor fails to appoint sufficient judges. There is a shortage of clerical staff and clerks. There is no oversight of guardians who violate court rules and abuse and exploit the people whom they are designated to protect. The Massachusetts Family and Probate Court system has been failing for some time. In 2011, there were 11 judges scheduled to leave that year. And now this year, there are 25 judicial vacancies with greater than 1,300 less court employees. There was a hiring freeze put in place since 2008. One keeps asking, when will there be an oversight contingency that steps in to take over this failed court system? But there never appears to be an answer. There is no level playing field. Without substantial resources, one cannot confront an abusive guardianship. And even if one tries, the outcome is predetermined before stepping into the courtroom. On the few occasions that my sister and I had representation, this individual, charging more than $600 an hour, told us that the matter of arbitrarily forcing my mother from her home would be decided in favor of the guardian and that we should agree or face being denied access to see our mother. We were told that said guardian was doing this out of spite and that she would get away with such conduct. She brought 4 or 5 people with her and billed my mother to be subjected to unspeakable physical and emotional distress and submit to a chemical restraint, an alleged belief that my mother would not be cognizant of her surroundings. This guardian's rushed, ill-conceived care plan backfired and harmed my mother. In my mother's situation and in the situation for other unfortunate individuals ensnared in the Massachusetts guardianship system, the probate court has a failing infrastructure, severe personnel problems, budget cuts, lack of guardianship oversight resulting in such conduct as guardians failing to file accountings, charging excessive fees, and breaching fiduciary duties, and using chemical restraints in violation of the Rogers cases, which have become a vehicle for assembly line involuntary psychiatric drugging orders, and judges who rubber stamp whatever a guardian presents in order to clear their docket. The following is a brief synopsis of the abuse that my mother endured. This guardian ignored court rules and paid herself every month without court approval. She engaged in accounting irregularities, refused to be transparent, refused to turn over needed documentation for others to complete accountings, and not until I obtained a lawyer did the so-called guardian submit a preliminary accounting 2 years into this guardianship. She was remiss in turning over needed information for completion of my mother's final tax return. She ignored my mother's wishes on every level. She ignored my mother's repeated requests for this guardian to remove herself. And apparently this person lacked the personal and professional integrity to respect my mother and treat her as a human being. She violated such constitutional rights of my mother as notice and the right to attend hearings. My mother on more than one occasion asked to go to court to express her wishes to the judge, but this so-called guardian prevented her from going. She left my mother without funds for medication and clothing, such that my sister and I would have to cover for this neglect. She failed to remove less than adequate caregivers. Again, my sister and I would have to cover for her neglect. She failed to repair leaks from around the chimney into the living room and failed to address other home maintenance issues. She removed my mother from her home and forced her to travel twice a week for 1.5 months in the winter without proper winter clothing between non-ergonomically suited lodging in Tingsboro and Woburn, causing her severe emotional distress which exacerbated her heart conditions. She put my mother at risk by placing her in her home with an individual who was on medication for depression and who was mandated to undergo counseling for child abuse. She authorized a chemical restraint because my mother was distraught at being removed from her home, and then placed her back in her home 1.5 months later because the chemical restraint did not work, and my mother's cardiac issues were difficult to regulate. She threatened my sister and myself whenever we objected to this individual's care of my mother. She was threatening to throw my mother into a nursing home and to deny us access to see her. She engaged in unnecessary court actions to increase her fees. She used a health care agency liaison to protect herself from liability. She depleted estate assets to the extent that my mother was forced to stay in rehabilitation facilities from December of 2009 until her death in March 2010. Such callous action resulted in my mother losing more than 20 pounds and succumbing to a systemic infection that was less than adequately addressed in 2 of the 3 facilities. She failed to comprehend how sick my mother was until approximately 2 weeks prior to her death, when this guardian had a conversation with a clinician at Newton Wellesley Hospital. Such an epiphany came too late for my mother. I tried to impress upon the court that forcing my mother to stay in these facilities against her will would result in her rapid decline, but apparently nobody was interested. This guardian had the hubris to tell the judge that she and her hired physician had conducted drug experimentation on my mother while she was in one of these facilities, and requested that a dosage of medication be increased. This is perhaps the only time that I saw this judge have pause concerning this guardian's request. The dose increase was denied, and the guardian's current dosage was not adhered to because medical parameters dictated otherwise. Apparently, this guardian was trying to force my mother to take a harmful medication in violation of the Rogers cases, which established that a person has a right to refuse to submit to invasive and potentially harmful medical treatments, whether the individual is competent or incompetent. This guardian was always threatening to throw my mother into a nursing home and file a Medicaid application. And based on everything that transpired, this guardian used the legal process to intimidate my sister and me, and was far less concerned with my mother and her health than she was with getting rid of my mother's money and the family who objected to her conduct. Unfortunately, this guardian was put in place against my instructions and those of my sister. Our alleged representation signed off on this guardian without our knowledge, apparently because it was expedient for him. Yet in more than 4 years, he was unable to complete a basic accounting because apparently it was more advantageous to procrastinate and continue billing. There is no court oversight of lawyers functioning within the Massachusetts family and probate court system, and thus these individuals know how to take advantage of a broken, failed system and exploit it. The Massachusetts trial courts have undergone audits since at least 1970, and these audits are called for by the existing governor at the time, Mitt Romney being one of them. And there's a running list of deficiencies that are produced from these audits every single time, and yet it appears that nothing is ever really done. One such report came out done by Harboridge House, entitled Justice Endangered, a Management System of the Massachusetts Trial Court. And I'm just going to touch on a few salient points that were highlighted in this report. The trial court is a system in name only, operating on automatic pilot and carried forward more by past momentum than by any compelling vision of the future. The trial court can control neither the increase in the number and complexity of cases filed before it, nor the resources available to it. Trial court efficiency is impaired by its existing fragmented and overly complex departmental structure, i.e. a collection of medieval fiefdoms. Vague or apparently conflicting provisions of the law governing the trial court administration raises serious questions about the ability of the management system to hold accountable or discipline local managers. The court business is scheduled largely for the convenience of the trial court and its employees rather than the public. There are existing threats to the quality of the bench and its performance. There is inadequacy in both the pre-bench and the recurrent training, and also there's a large number of judicial vacancies. There is judicial opposition to performance evaluation, little substantive communication between the Supreme Judicial Court and the trial court leadership on administrative matters, and few attempts at the consultation between the Supreme Judicial Court and the Office of Administrative Justice and the administrative justices of the trial court departments. And lack of accountability on the part of the judges making decisions, since judges are appointed for life in Massachusetts. There's a widespread feeling inside and outside of the system that no one is truly in charge or accountable for the performance of the trial court. Under Massachusetts General Law, Chapter 211, the Supreme Judicial Court has the power of general supervision of all courts of inferior jurisdiction, yet it's abrogated its responsibility. The Supreme Judicial Court and the Departmental Chief Administrative Justice avoid difficult administrative decisions. These blatant deficiencies are regurgitated every single audit, and yet nobody seems to do anything about The legislative branch ignores it, the governor ignores it, and it appears that the Chief Judicial Court, in abrogating its responsibility, leaves responsibility to the administrative office, and yet they have no authority upon which to act to make corrections to the problems. And this was reiterated in an article by Dan Ring in the Republic dated May 2nd, 2010, entitled Massachusetts Trial Court Suffers from Organizational Dysfunction, where it reiterates these deficiencies once again. So there's indifferent behavior on every level, on the legislative part, the governor's part, the judicial part, on the judges sitting on the bench, indifferent behavior of the guardians. And this indifference, this neglect, resulted in my mother being placed in less than an adequate rehabilitation facility, where the staff could not even recognize systemic infection and partial kidney failure. All of these entities contributed to the untimely death of my mother. And it's a shame the probate court system tries to give the impression that they have overarching jurisdiction when in fact their jurisdiction is very limited. And they do not have the jurisdiction to hear such things as a breach of constitutional rights or to look at breach of fiduciary duty or malfeasance. And yet they leave you with the impression that they do, and when they really should be sending this type of issues to a different venue.